the heck you doing sitting down? Get your butt up and train.
Man, we seen that shit. Oh, I shouldn't have said that.
Let's move right along. So I'm going to talk about some case law, some things that I get all the time from my security people that have problems with police officers, or police officers that I've talked to that have had problems really understanding the law. Alright, and what I'm going to start with is really talking about the Terry versus Ohio, because everything really boils back down to Terry stops and Terry frisks. When you really look at it, at the end of the day, everything always boils back down to Terry versus Ohio. Okay? Let's read one from Florida versus Royer. It's United States Supreme Court case law 1983. It says, neither inarticulable hunches nor unparticularized suspicion will suffice to justify an investigative detention. What does that mean for you officers out there? You do not have the right to make up things when you stop people. You do not have the right to not have articulable facts. Okay? Not articulable hunches. Not, I've been in police for 50 years, so I know. No. It's based on articulable facts that a person is about to, or is committing, or fleeing from the commission of a crime for you to have an investigative detention. Okay? And if you need reference to that, you can go to United States versus RV Zoo. You can go to Terry versus Ohio. And you can also go to, let me flip down here, United States versus Black. It says that, and this came out in 2013, it says that the court made it very clear that it will not tolerate an officer's misuse of innocent facts as indicators of suspicious activity to detain and or search people. It says the court further said just because an officer has a reasonable suspicion that an individual in a group may be engaged in criminal activity, that reasonable suspicion without further indicators does not apply to the others in the group. It says the court further stated that the government attempts to meet its Terry burden by patching together a set of innocent, suspicious-free facts which cannot rationally be relied on to establish reasonable suspicion. Hope you guys understand that. You have to have facts, not hunches, not jokes, not I think. Alright? Facts. Alright? That what? A person is armed and considered dangerous to pat them down. Reasonable suspicion of a crime that has been committed or is about to be committed to stop them. Okay? Brown versus Texas. You cannot stop a person merely to identify them without reasonable suspicion that a crime has been committed. Florida versus Bostic. It says the standard for determining a seizure is not if the person feels free to leave, but whether the person feels free to decline the request of the officer. Florida versus Bostic came from a case basically where a guy was on a bus. Florida officers were doing drug and addiction on buses, like a bus stop, and they said that he didn't feel like he could leave off the bus, so he gave the officers the right to search because he felt like he had to. He was basically coerced under the power of the badge. Okay? I didn't make this stuff up. That's what the case law says. Florida versus JL. Officers do not have the right, after a 911 call of a man with a gun, to go and search a person just because they get a 911 call for a gun. It says you must have articulable facts that provide that that person is carrying a gun illegally before you can detain him investigatively and perform a search of his person or pat down of his person to locate that said firearm. Basically what it boils down to is you do not have the right on a 911 call of a man with a gun to walk up to somebody and demand them to tell you what the 911 caller just found. If you have no other facts to support the 911 caller, then you cannot proceed as such. Same thing for Wagner versus State in the state of Georgia. Without probable cause, a 911 is not enough. 911 call is not enough. It does not constitute probable cause. Moving along. U.S. versus Aquino. This was out of the 8th Circuit in 2012. It says the court held that seeing a bulge in somebody's pockets in it of itself does not establish probable cause to conduct a search beyond a pat search of the outer clothing. Okay, what does that mean for a lot of officers? A lot of officers pat people down and say they found drugs. A bulge is not enough to constitute that probable cause for you to say that you have found drugs. I know a lot of officers like to use this, but that's just not how the case law works. Okay? Another case, and it was Purdue, it was a case of Purdue Supra. Alright, it says, but the detainee has no obligation to respond to an officer when they ask them questions under a Terry stop. They have no obligations to respond to you officers. Okay? A lot of officers try to force answers out of people and tell them, you have to tell me. Okay? Under that Purdue Supra, you do not have to respond if you don't want to. It's called the Fifth Amendment. Alright? Moving right along. About some things that some of my security guys always have problems with. And then I'm going to be up out of here. It's about 15 minutes. Alright? Let's check this out. City of Marion versus Kelly. And I'm just going to read this part right here where it belongs to security officers making arrests. This City of Marion versus Kelly came out in 1985 where a security officer arrested a guy. City of Marietta police came out and handled the arrest. It says that the police arrived 20 to 25 minutes after they were called, and a Marietta police officer assumed custody of a appellee. It says this transfer of custody to a law enforcement officer was one of the alternatives. What does that mean? There's options. What's the other option? The person can actually take that person arrested before a judge. He does not have to call the police. Okay? It says one of the options available to the arresting private citizen in order to comply with 17-4-61, which is the arrest law in the state of Georgia. It says such a transfer of custody of an alleged offender already arrested by a private citizen does not involve a decision to arrest by the law enforcement officer. It does not involve a decision to arrest by the law enforcement officer. Furthermore, seen in regard to OCDA 17-461 B and C, it says regardless of the officer's subjective intent, the alleged offender's liberties have already been restrained during the arrest by a private citizen, and there is no logical analysis under which the police officer can be viewed as arresting the appellee. So, what does that say? When a police officer comes on scene and you have somebody already arrested, they do not have a subjective intent to change what has already been done. Okay, they cannot come in and undo what you have done. Alright, and that's City of Marietta versus Kelly for your arrest laws. Okay, last but not least, I hear a lot of my security students talk about how police officers tell them that we have to be there to give a criminal trespass. You can't criminal trespass anybody without us. Okay, well, let's go to Jackson versus State. State of Georgia. When was Jackson versus State? Let's see. Was in 2000. Jackson versus State of 2000. This is what it held. It says that they reversed the conviction because there was no evidence that the patrolman, which was a police officer, was acting as an authorized representative of the owner or rightful occupant of the apartment when the police officer warned the defendant to stay away from the apartment. Jackson versus State says that police officers who are not working for the department cannot come out and give somebody a criminal trespass. And if they do and arrest that person, it will be overturned because they are not a legal authorized representative for the owner. Okay? Now, in Reed versus State, 1997, it was a very pivotal case for criminal trespass for security officers. A security officer by the name of Capote was inside of a hospital who told Reed to get up and leave because he was being disruptive. Reed said, "I'm not going anywhere." The security officer said, "If you don't leave, sir, you will be arrested." Mr. Reed did get out of his seat and started to walk away. Well, as he started to walk away, he turned because he saw his wife, and he started to proceed toward where his wife was at. Capote, the security officer, turns around and presses him up against the wall and immediately places him in handcuffs and tells him he is now under arrest for the crime of criminal trespass and refusing to leave. The trial court, which was the Georgia Court of Appeals, affirmed the conviction and said that the security officer, being the fact that he did give him a warning to leave, and that it was applicable enough because under his own testimony he advised he was told to leave, that was enough to satisfy the 16-71 criminal trespass conviction, where it says that a person that refuses to leave an area after being warned to do so by a rightful occupant, the owner, or authorized representative, is now suffering from that law. Okay, Reed was arrested, he was convicted, and his appeal was confirmed. Now we look at Sheehan versus the state, all right, where it involved the same type of decision, and I want to read verbatim from it. OCDA 16-7-21, which is the criminal trespass law, B Bravo 2, says that permanently provides that a person commits criminal trespass when he or she enters upon the land or premises of another after receiving prior to such entry notice from the owner, rightful occupant, or upon proper identification and authorized representative of the owner or rightful occupant that such entry is forbidden. That this is essential to establish the establishment by the state of offense charged, where it showed that Sheehan's entry into the premises had previously been expressly forbidden. It says the statute also requires that notice to not enter the premises be given to the accused by the owner, rightful occupant, or by the authorized representative or the rightful occupant. Okay? I don't read in any of these case laws where it requires police officers to come out and verify that you have given somebody a criminal trespass, nor does it make your case any stronger or weaker if they come out and do that. So I hope you guys are watching this, you both police and security, and you guys can get along out there, alright? Because the law is the law. You must know your law. And on top of that, you must know your case law. I know a lot of guys are probably going to argue with me about this video. So what? Alright? Check it out. I know my case law. And if I don't know it, I go find it. Okay? Your job is to get out there, find it, and apply it appropriately. All I want you to do is do your job. And for you civilians, press record. Alright? Keep everybody accountable. That's all that I ask. Keep everyone accountable. Alright? Accountability is how you get things done. Alright? And for you officers, I don't want to see you guys in court. Do the right thing. Keep yourself accountable. Press record yourself. Okay? It's too many complaints, too many fraudulent complaints out here. Too many fraudulent videos on YouTube not showing the full story. Okay? I'm not just for the people. I'm for everybody. Alright? You guys out there that are open carrying, stop being buttholes. Some of you guys are quoting the laws all wrong. Okay? If you're going to get out there and open carry, please know your law. Please know your case law. Know what the heck you're talking about. Okay? Because I would hate for you to get embarrassed on your own camera while you're sitting there trying to put it on YouTube. It makes no sense. You know I love you. Guys, this has been another one from Instructor Turner. I'm going to get some hate fan mail for this one. I don't care. I don't care. Alright, but y'all stay true. Alright? Win that goddamn fight. You know I love you. I'm out.